Today we're going to talk about transferring title. This is an aspect of the real estate transaction. It's generally handled by lawyers and title companies. People need to understand the legalities of what they're doing. The title companies are really good about reviewing legal descriptions of the deeds to make sure that they are spot on. Typically, one person will read it while the other person looks over the document to make sure that everything is in agreement, because if you record a wrong title description, later in life it can come back to haunt somebody. So they're very sure about being accurate when they're doing all this. The real estate professional who is aware of fundamentals of deeds and title issues will be able to alert consumers to the need for legal advice to avoid potential title problems. Remember, we're not attorneys as realtors, but when we see title issues or title problems, we are the ones that are going to want to say to our clients, hey, wait a minute, stop. Let's seek the advice of legal expert, legal counsel, so that we can get these things resolved. Maybe we need to get a new survey prepared. Maybe we need to do something for the property to make sure that we can have a good title to be able to do the transfer. So when we talk about the objectives, we're going to talk about the fundamental concepts of title as it relates to the ownership of land and the processes and instruments used to apply these concepts. We're going to describe the circumstances and conditions which may provide for the involuntary transfer of title. Involuntary, remember, we didn't choose to do this, so it's involuntary. And then we're going to talk about testate, intestate wills, and the probate process. Unfortunately, wills is part of involuntary transfer. When you die, you're not choosing to die, but that would be part of the involuntary transfer. But if you have a will, you can direct how things get transferred and what's done. So the title concepts that we have, there's something called voluntary alienation. The grantor conveys the property to a grantee. The grantee receives the property from the grantor, and then the deed is the instrument that conveys property from the grantor to the grantee. This whole thing about voluntary alienation is the fact that this is something we want to do. We've entered into a sales contract. We're actually bargaining and selling the piece of real estate. So the grantee and grantor are involved in the transaction. The requirements for a valid deed. Again, this is kind of like a contract. We've got to have certain things on it. We need to know who is the grantor, who's the grantee, what's the consideration. Is it $1 and other valuable consideration? Do we actually list the sale price? Some counties require us to actually list the true sales price. We have a granting clause that says we're granting this real estate to somebody. There's the habendum clause, which is part of that granting piece. We have the full legal description of the piece of real estate. And then we'll have exceptions and reservations. When we have easements or sewerage easements or things like that that are going on, we can have exceptions and reservations when we're writing this legal description. We have to have the signature of the grantor. It has to be signed by the grantor to be valid. An acknowledgement, this is where a notary or an attorney is acknowledging the signature of the grantor. Understand this acknowledgement process is very important in the title piece. The acknowledgement is the notary saying that this is truly this person that signed this document in front of me. And then we have to have delivery and acceptance. The title has to be transferred, has to be delivered and accepted by the person buying the property in order for this to be a complete transaction. Just recording it in the county records does not assure delivery and acceptance. You've got to get to that next stage to get it all the way done. Types of deeds. This will be interesting to know. This is a short list that you need to become a little familiar with when you're doing the state exam to understand what these deeds mean and how they're used in real life. We have a general warranty deed. We have a special warranty deed. We have the bargain and sale deed. We have the quitclaim deed. We have the deed of trust. We have a reconveyance deed. We have a trustee's deed. And then we have the deed that's executed pursuant to a court order. So that last piece would be part of that involuntary transfer when it's going through a foreclosure process or something like that. Or the divorce decree, or the court order could be probate court. General warranty deed. This is what we're trying to do when we sell residential real estate for the most part. The general warranty deed is the best deed. And it says to somebody that we're going to go back in and insure title. We own this piece of real estate. We've owned it for a while. But we'll go back in history, back in time, and help somebody make sure the documents are good, make sure the title company can get good documents to transfer this title, and make sure it's a good title. The special warranty deed is something that we use in commercial real estate. Corporations, because they're not truly individuals, cannot issue something called a special warranty deed. They have to, or a general warranty deed. They have to use a special warranty deed when they're selling property. The bargain and sale deed is exactly that, in a bargain and sale. Quitclaim deed is used in divorce a lot, and it also might be when partners want to dissolve the partnership or convey property to the other partner, but they're really not getting money for it, but they're already titled. So a quitclaim deed says, I'm just exercising my right to tell everybody that I no longer have any claim on this title. I'm going to sign this paperwork that says that I'm giving it to somebody else. Deed of trust comes through this whole trust instrument. We used a deed of trust a lot when I was in the trust department because the trustee actually holds title to the property, so the trustee can convey the property through a deed of trust. Reconveyance deed might be just simply duplicating a deed that was done to make it legal because something was done wrong, to make a correction in the deed. A trustee's deed, again, similar to the deed of trust, what we were doing before. The other piece of a deed of trust might be when you're doing a land installment contract. It would be where a deed of trust might be something you would see more often. And then again, that deed executed pursuant to a court order, through a divorce decree, from probate, or through a foreclosure action. Transfer tax stamps. I've never actually seen stamps issued. Years ago, they actually did. When we were little girls, our families collected S&H green stamps. We got stamps when we go to the store and purchase something. We'd put them in a little catalog, and then we'd go back in and say, okay, now we have so many stamps. Can we buy this with these stamps? We don't actually see the transfer stamps happen at the county courthouse where they're recording things. They stamp the document with rubber stamps to date and put where it can be found, the filing, and things like that. But the transfer tax actually happens when you're paying. You are going to pay a transfer tax when the title is transferred to another party. So there's a transfer declaration form that you fill out. That this is where you might say how much was paid for the property, where you pay the taxes based on that. And then there are exemptions for transfer tax when you're a nonprofit or there's some other circumstances going on where you're not actually going to pay tax on the transfer. The involuntary alienation. Like I said, this is where you didn't do this by choice, but a sheet is where somebody dies without a will. The property is going to go to the state, and the state will do everything they can to try to find beneficiaries and heirs of the family and property, but if they can't, the state gets it. The state has to maintain it, but the state will sell it and keep the funds. We have condemnation by the state's power of eminent domain. Again, this is typically not something we're doing voluntarily. It can be once we're paid and we're satisfied with the arrangement, but it's typically not something we're trying to go into voluntarily up front, but we have eminent domain. Foreclosure is exactly what it is. The bank is taking the property back. Adverse possession, when somebody else is taking the property, it isn't through a bargain or sale. They're taking it because they've, quote, adversely possessed the property for the period of time, and they can make claim on the title. Again, that's an involuntary thing done by the person who owns the property. Somebody else has come on their property, maybe through a trespass action, but they've been there for a long time, and they basically can get title through their actions. Adverse possession, this is, again, this process of going through taking somebody else's property. It's open, it's notorious, it's continuous, it's hostile because it's done against the will of the owner, and it's adverse. It's again, against the will of the owner that we're doing this adverse possession. Years ago, when I first took these real estate classes, I thought adverse possession meant you also had to pay the real estate taxes on it because that was one of the ways you were declaring that you owned it, but that's not a requirement of adverse possession. Adverse possession varies from state to state as to how many years you have to have this, quote, possession in this whole continuous process. When property transfers or sells, or there's a new buyer coming in and they don't know that they're, quote, taking this part of this property, the adverse possession may not become continuous, and therefore they could lose the claim of that adverse possession. Where an adverse possession might happen a lot would be the encroachments, where property encroaches against somebody else's. they're open and notoriously doing it, the neighbors kind of agree to it, but it's not something they say they want to do. And an example of that might be where my driveway encroaches on my neighbor's property by a couple inches. Is it open and notorious? Absolutely, it's right out there. But do my neighbors know the difference? No, because we don't have the survey line staked, and we don't have a line running across the property to say, oops, sorry, you stepped over that line. So that could be a form of adverse possession, would be an encroachment. Conveyance of a decedent's property. Somebody dies, and they'll convey their property by will, by descent, or through probate. By descent would be through the heirs, their natural-born heirs, and who's part of their family. By will, again, this is how, when you're alive, you choose how your property is going to be distributed when you die, and you can direct how this is all done by a will. This is also part of the trust process. If you set up a trust, it's as good as having the will in place. It directs how your property will be transferred. And then probate is what you have to go through when somebody dies. There's a probate division of the courts where they ensure that the documents are accurate and filed and done in a manner and such that it meets the laws and requirements for the death of somebody. So it goes through probate court to have it done properly. And that is it for transfer of title. You'll learn more as you read. If you have questions, let me know.